Hey guys, and welcome to the weekly docket. Hey guys, good afternoon. Has anything happened in any cases this week? It seems like maybe it has. So let's check this out. I updated it this morning after updating it last night. Probably still not current. Let's hit it. So Richard Allen, yesterday, the court released a lot of documents in the case, but not all of the documents, right? Some of them are still under seal. And obviously those are probably kind of interesting. That's why they're under seal. But something like 100 were released, and it happened right after the member stream where we talked about the motion in limine for the ballistic evidence, and had done a video on that before, and that's the cartridge found at the scene. So what we predicted in that turned out to be pretty accurate in terms of the motion. But there are other things that made a little bit more of an impact in the news, and we'll just hit one or two of those here. So confession, is it good for the soul? The state pointed this out in its argument, saying that, look, if the defense is going to get records of what's going on with Allen while he's incarcerated in terms of his mental health, to try and say that when he was making incriminating statements or confessions that he was not coherent at the time or babbling, or for some other reason the statement should be disregarded, the state should be able to see that too, to see if it's accurate or not. And that makes sense to me. Of course, in this little blurb I have here, it says the defendant admitted he committed the offenses that he's charged with no less than 5 times while talking to his wife and his mother on the public jail phone. There were some more details that I posted, I know have been posted everywhere else too, about what was going on with his wife on the telephone call. And then I guess she terminated the call, and I don't think he's talked to anybody on the phone since then. So that's kind of a big deal. Does it mean he's guilty? No, it doesn't mean he's guilty. But just because he's having a hard time in jail, does it mean he wasn't telling the truth to his own family? Yeah, I don't know that it means that either. I don't see any reason to definitely conclude one way or the other, but it is certainly the case that if your client is confessing to his own family members on the telephone, that's something, if you're the defense side, you wish was not happening. They also mentioned in some other documents that a knife was used in the murder. The people have pretty much surmised that. What articles of clothing were missing. Full witness names other than minors were also contained in that. So a lot of detail is provided finally. All right. How about Bryan Kohberger? Anything happening in that case? Yeah. Let's take a look at a few of those things. This one's getting a lot of time on social media with some good arguments in both directions and some not good arguments in both directions. And everybody can have their own opinion, but not everything is in the realm of reason these days. Unless aliens do show up, then everybody can just say whatever they want. Let's take a look at some of this. Put it like this. So getting started again on this DNA evidence, because that was a motion to compel, or subject to a motion to compel, that ended up being put off from the hearing that we looked at the other day. But it's important both for the state and for the defense. And the state said, listen, this is a 5.37 octillion times more likely that this DNA is the defendant, the source, than somebody else. And I don't know, and I think the defense makes a good point, that this is really the right way to say that. And I say that as they point out in their brief, talking about the prosecutor's fallacy, basically saying these odds are the odds that he put it there. And there are other things that can impact those odds that aren't included in that. So it's definitely overstating the case. And the defense is right there. However, saying that doesn't mean that it isn't highly conclusive evidence. I shouldn't say conclusive. I should say highly relevant circumstantial evidence, because it's not conclusive. And we'll go over some of the reasons why it's not. It's a Freudian slip, because it is persuasive to me. But this kind of quoting of statistics by the prosecution, it's a subtle situation, but the defense is right to call it out. I gave an example a few days ago about, if you have a 1 in a million chance of error in a DNA match, say here in North Carolina, and we have 10 million people, that means it could be any of 10 people. So then the defense could say, well, if there's 9 people that weren't the person and only 1 that was, the chance of my client being that person is only 10%. So you must let him go, because that's not beyond a reasonable doubt. There's a lot of flaws in that reasoning, just like there is on the prosecution side. So DNA is normally circumstantial evidence. It is here, and it's important to either side potentially, because the defense has some things it wants to say about this and also about other DNA evidence. But it's definitely important. People expect to see it. And when they do see it, it convinces them that law enforcement either is on the right track or on the right track. It changes a lot of minds. That's just the reality. And I want to say thanks to Marshall Lynn for helping this channel survive and promoting the graphics packages that I'm able to get with generous donations. All right, let's rock it down to what was at issue in the DNA discovery. So there's kind of three things in this really that matter, and that is the comparison of the DNA profile on the sheath to Kohberger himself personally, and the state agrees to turn that over. That profile was developed by the Idaho State Lab, not the FBI or anybody else, and it was once they had a sample of Bryan Kohberger's DNA from a search warrant, they were able to make this direct comparison. So that the state is going to contend is the most relevant information here. And they agreed to turn over the stuff about it to the defense. The sheath to the family trash. So that's when they went and got a piece of trash out of his family's house in Pennsylvania and matched it and said, this is probably the father. High odds that this is the father of the person who left the DNA on the sheath at the scene. And the state says, yes, we'll agree to turn that over. And those two things were part of the probable cause affidavit, but not the second thing was, family trash. And then the top one was after he was arrested. So those things the state says, yeah, that's relevant. Okay. And we'll give it to you. But the most relevant thing is the comparison to his individual DNA to that on the sheath, not whether somebody in his family was potentially associated. And that gets to item 3, comparison from the sheath DNA to the genealogy database. Now, the FBI ended up developing a profile and a private lab to work some on that. It's a different kind of profile put into this database, and that plus other research leads them to say that, here's the family that this person probably came from. And the state says, we don't need to give you that stuff. And I'll go over the arguments. It's not relevant. It's the primary thing. And I kind of buy it because to me, for example, they're right. If you compared the sheath to Bryan Kohberger and it was someone else, this family tree stuff couldn't be used against Kohberger. It would have nothing to do with it. And now that you do have his individual match, the strength of that, it really is what matters, and not whether the link to his family is strong or not in terms of trial evidence. So let's see what the arguments were. The state says, look, it's not relevant, as I just said, because we have the state lab match. We're not going to use that stuff at trial, this genealogy, family tree stuff. It's not evidence of guilt or innocence, because if it was somebody in his family, that doesn't mean it was him. It doesn't mean it wasn't him. Then they said, it endangers family and informants. They kind of classified people who put their DNA into these databases as informants. That's not a good argument. The defense picked that apart, and they did a good job. The defense says, hey, look, we need this information to ensure that no one else put the DNA on the sheath. Yeah, no, I hear that argument, but okay. They didn't plant it there, or somebody else put it there, but you go. I hear you. I do hear you. They say that witnesses and intellectual property of the private lab, hey, that's not a reason to not give us discovery. We can deal with that with a protective order. And here I think that the defense is certainly correct. They're right there. And they say the DNA database participants are not informants. They're people who voluntarily use these profiles, and they know they're going to be seen by other people, and they're certainly not informants to police. And I absolutely agree with the defense on this. They also made a comment in their brief that it's suspicious that the FBI chose to do this themselves instead of having a blind lab do it. I don't agree with that. I mean, the FBI is it's right in the name. They investigate stuff, right? So, yeah, I don't trust DC FBI. A lot of people don't. Some people do, but this is their business, is investigating things, and they analyze evidence and they do investigations. And I don't think we need to say if they don't outsource all of it, then it is suspicious. That doesn't make any sense to me. But they did say that, listen, how they got to Kohberger and the leads, the conjunction of leads and things like that, is kind of the first domino that they shouldn't be foreclosed from knowing how this investigation got going and stuff. And that resonated a little more to me than I thought it would, because I discussed with somebody in the comments who said that, that the defense is really just asking them to show their work, like on a math problem. And I contended against that, saying that they are, because they're willing to give all the information from the development of the STR profile by the state lab that was matched to Kohberger that they're going to use to trial. They get all of that. And that this whole family tree stuff is more like how you learned math in the first place, not the specific problem. But I see this other side of the point as well. And their follow-up argument to that this could impact the statistical analysis of the profile by the Idaho State labs, I didn't catch exactly how they said how that would occur, but the logic of that to me is kind of a winning argument. If in fact it changes how they handled anything or changes the odds of how they calculate anything, then I think the defense should see that, because it would tie it then to the evidence that even the state says it's going to present. So I like that argument, even if I didn't fully understand it. They also mentioned other DNA profiles and investigation communications that they want, and that's probably reasonable too. I think if you watch this hearing the other day, you can see that the defense team is being very, very professional in the court and also in their filings. So I don't agree with all the arguments the state makes or the defense, but they are all doing a good job of trying to stay focused. The judge hasn't had to get aggravated with either side, and it's been able to have reasonable discussions with everybody. And they have worked through most of the discovery issues. So these are important, and sometimes you have important things you have to have the judge decide. That's what the judge gets paid for. So I have no issue with the defense seeking this and the state trying to say, well, here's why we don't want to turn it over. It's not, 500,000 things. It's just a few things, and the judge will decide it if they can't figure it out. But the state asked for more time to respond to the defense arguments, and the defense did not object to that. Again, being pretty reasonable. So I wanted to put the slide in here because there were some comments before we got rolling in here, about theories on this case or any case. So I'll just tell you how I look at it. So evidence that I see, is it going to be admissible or not? Is this something that should impact the trier of fact? Is it the kind of evidence that can be admitted into court? Some rumor somewhere, or actually something that would come in? And what's the weight of it? What would I think of the weight of this evidence? And what could I say 12 other people might think about it? Like, a DNA match that's highly certain. That's pretty persuasive to me on the point that it's trying to show. Context and other circumstances are important, but a jailhouse snitch, for example, saying he told me that that he killed the guy, now give me a year off my sentence, that maybe doesn't carry so much weight, right? And the context of things. Let's take, for example, this DNA sheath or sheath with the DNA on it. There could be important context about that. So even if it's Kohberger's DNA on there, in theory, there could be explanations for that. And maybe somebody stole it from him, broke in his car and took all the stuff or whatever, stole his car. Now, I don't think those things happen or that they're even saying that. But if someone had stolen Kohberger's car and had his knife in it and was wearing gloves while he did it, there could be completely innocent explanation for his car being in the neighborhood if it was his car, and the sheath being on the bed with his DNA on it, right? That's why it's circumstantial evidence. So you got to know context and unknowns. Let me hit this because this comment, because sometimes they disappear. So Tom says, do you think there are more involved? And I think you mean more than one person involved in this Kohberger crime. So I'll come back to that in just a second. And thanks for asking that. So that's kind of how I look at evidence, or try to. Now, you don't just look at evidence in your mind. You're trying to develop a theory of the case, right? And the state's theory is always this person did it. And the defense theory is either the state hasn't proven that or someone else did it, pretty much. So when you're looking at your theory, try and see how it tracks with the evidence. It's not just your assumptions that you put onto a case. I hate the government, or I know the police lie, or the scumbags the police pick up, they're always guilty and trying to weasel their way out of it because defense attorneys are, crooked or something like that. I mean, that's if you want to think that way, that's fine, but that's not dealing with the evidence in any case. And you should, because some cases they got the right person, some cases they don't. So test the theory that you're developing and see that it tracks with the evidence, because if it doesn't, you need to think about that. And is it logical? I'm not saying it's aliens, but it's aliens has historically been considered illogical. That might change by the end of this year, but you get what I'm saying, I think. And probabilities. That goes a little bit to the aliens thing. If you can think of some outlandish theory like the eagle of innocence dropping a bullet or something like that, just because you can imagine it doesn't mean it warrants consideration as any kind of reasonable probability. You don't go just on probability, but it's an important way to test your own vision of your own theory. And unknowns. So on evidence and theories, we're just observers of the case, and there are unknowns to us. Even the parties in the case can have unknowns. Take the Richard Allen case. Before he called his wife purportedly and confessed, if he did or even if he didn't, but before that happened, they had no confession by this guy or statement that I did it. So that actually happened during the case, and it's going to change the dynamics of the case. So there are unknowns that you just don't know about, and then things that can occur during the case. I mean, until they released the probable cause affidavit in the Richard Allen case, nobody knew they found a round there. So there could be other things we just don't know. That brings up a bias that we all bring to the table. And how do you check it yourself, other than arguing with each other on the internet, which doesn't always be the best way to do that. And I guess sometimes I try to tell myself to be sure I'm working forwards and not backwards. So I don't want to look at some new piece of information, like, say, Richard Allen, and let's say I think he's guilty. And now that he's confessed to his wife, that just proves it. It's absolutely guilty. You have to work forwards. And so you look at that in its own context. Consider the defense argument, of his mental state, things like that. We don't know exactly what he said. What is his wife going to say he said? Well, how does a recording sound? All those things matter. So the fact that I might think they have the right guy shouldn't by itself improve the quality of this evidence. The evidence is what it is, and you work forwards with that. Now, it would support your idea that he's guilty if you think that, but it's not by itself going to take that, to me, to a conclusive range by itself, or it shouldn't anyway, because it's just so much we don't know about it. And I think a good check on that is your certainty level. One way to look at that is to every time you hear something that the other side says, you're just sure that they don't have any point. They have no point at all. Nothing's important. So if you think, for example, that Kohberger is innocent, then every time the state brings up a piece of evidence or circumstantial situation or something like that, you're able to just completely throw it out. They have no points. There's no case against this guy. And likewise, if you find yourself thinking, even though he has a talented defense team, that every single legal argument they make and every circumstance they bring up that they think people should consider it can't be valid because look at the DNA on the sheath, bro, then you're throwing out a lot of what's in the case without actually thinking about it. So if your certainty level gets too high, especially when the case isn't over and we don't even know what all the evidence is, then you might be letting your bias drive your opinions instead of the evidence and things. That's just my thoughts. And from that, I say, premises aren't conclusive, or what's the point? And here, I mean, the police generally get the right guy is a theory. And that's one reason why you have the presumption of innocence is to rebut that. But that doesn't mean that any guy that they arrest in any individual circumstance is the right guy, even if it is true. If it is that most of the time, or the majority of the time, the person brought to trial is the correct person because they get to decide who they bring to trial, it doesn't mean that every time that person's right. And presumed innocent. Just because you presume everyone innocent is not a reason to throw out any consideration of any real, actual, hardcore evidence and just go, well, he's presumed innocent, so I'm not gonna look at DNA. I'm not gonna look at a videotape or anything. I'm only gonna consider things that might support this person not being it because he's presumed innocent. The presumed innocence is a starting point. We'll get into that because we did a poll on it. And I'm going to hit this comment where it says, did I see the latest on Darrell Brooks' case? But keep your finger on the keyboard because we'll hit Darrell Brooks before we're done with this. And I want to get back to Tom's point. So here's an example of framing actually going on in the Kohberger case. Let me get this up big enough to where I can see it. These are from briefs that the state and the defense filed about the same thing, factual background. So here they're not supposed to argue in theory. They're just supposed to let the court know the relevant factual background. But I mean, lawyers argue every chance they get, so I don't fault them for that. But look at how they talk about it. So at the top, they say the 4 victims died from apparent knife wounds. This is the state talking. Law enforcement found a K-bar knife sheath on a bed next to the bodies of Madison and Kaylee. It was face down and partially under the body and comforter. Okay, and they seized it pursuant to a search warrant. So they found the sheath there, right? That's what a find under a murder victim. Now look at what the defense says. Law enforcement found a K-bar knife sheath placed next to Miss Mogan on her bed. It was placed button side down. Now, if something is dropped in a struggle, it falls inadvertently, it's not placed there. It is there. Placed, to me, it connotes a deliberate act. And let's say hypothetically you wanted to suggest that the sheath was, or you wanted to reserve the ability to suggest that the sheath was put there, say to point towards Kohberger, even if he wasn't the guy, then that could be a deliberate act by one or more of the assailants, right? It was placed there because it's potentially such an explosive piece of physical evidence there. So I thought it was very interesting to see them use that word placed there. I mean, none of us really know, other than the person who did it, how it was put there, whether it was dropped or whether or whether somebody put it there to point at Kohberger. I mean, if Kohberger dropped it there while he was murdering people, then I think the state's narrative is correct. And, they just found it there. And he didn't know he was dropping it at the time. He might have realized it later. If the defense theory that they seem to potentially want to promote that it was somebody else or something like that, then placed there is definitely a potential. So that is interesting that you'll see this is subtle, right? It's in the factual background. They want to shape how people are looking at this. And I think that's interesting. So in this case, this Kohberger case, because sometimes I get comments that other YouTubers say he's certainly innocent and stuff like that. Everybody can think what they want. I don't have any problem with that. Here's the way I see it. The state has very strong circumstantial evidence with this knife sheath DNA. And we'll talk about how the defense can poke a hole in it. But as it stands right now, a solid profile developed that results in a single source DNA that is matched to this guy. That's a big piece of evidence. It's not the murder weapon, but it's what it came in. I mean, that's pretty sweet if you're the state. If you think it's not important, but not for reasons of the evidence can be contested and things, I'm not sure that you're not just being biased there, because that's a big deal. And the defense knows it. That's why they want to fight over it. They also have circumstantial evidence of his vehicle travel and phone use, and unknown, because we don't know what else they have. And it's probably not nothing. I think I said that right. It probably is something. And then, of course, he's got weird behavior like bagging his trash and stuff like that, which I think is potentially relevant, but he could just be a weirdo. But he was wearing gloves and putting his trash in his own individual bags and sticking them into his neighbor's trash can. That could be just bizarre behavior, and it could be somebody who doesn't want their own DNA samples found if they can avoid it. I don't know the answer to that. On the defense side, they say, listen, maybe, and they don't concede it, that Kohberger's DNA was found on the sheath, but there were other profiles found in the house. I think they found a profile on the glove outside and some other guy there. So that's a point they make. They also talk about the limit of cell tower precision, that when you say you're tracking Kohberger's movements, but you're using it based on his cell tower reception of his phone, but not, say, GPS tracking of his phone, there's a lot of variance there, because radio signals do weird things, especially as you change from day to night. I don't know how the algorithms work to control their cell phone towers, but I get what they're saying, and it's a fair point. So lack of victim trace in the vehicle and home. And this is a good point for the defense, because so far as we know, they have not found something from the victim, a DNA or blood or hair or fiber or whatever, in his car or in his homes. And why not, right? He just killed 4 people and had to leave in a hurry. You think there'd be something in his car. It's a good point. And unknown stuff. I don't know what else they have or what else they may bring up. So that's kind of looking at both sides of the case. So in my opinion, the state has to establish high confidence in the DNA sheath, or on the sheath, in the process, in other words, how they tested it, and the probability that they're saying it represents, but not by itself. You tie that to the circumstantial evidence, the chain here, his car leaving, or a car identical to his leaving where he lives, his phone being turned off, and then the car, something that looks exactly like it, shows up in the neighborhood around the time of the murders, and then the murders occur, and you find the sheath in there with his DNA on it, and then later on, his car, that morning, his car appears back at where he lives, and his phone turns back on. It doesn't look too good. Now, the defense, I think, will attack the process of how the DNA was, or at least they want to. That's what they want this discovery for. They want to show the odds aren't nothing or anything like what the state is telling you. There are real issues with this evidence, and they should be allowed to pursue that for sure. I don't think the fact that there can be issues with DNA evidence that would invalidate it means that there are, but it is a line that they have the right to pursue, in my opinion. And so the process, maybe they screwed up or whatever, and what the real probability is. And then the circumstantial evidence of travel. And the big one, I think, is circulating online right now, which is where's the evidence in the car? And that's a good point. All right. Let's see. However, not everything is reasonable. So on this one, if you're in the pro-state side, just because they have a good chain of evidence against him, it doesn't mean everything he ever did supports that and is actual evidence, further evidence of his guilt. Be careful with that. So pictures of the guy, he's at this event, or here's a picture of him when, he has a strange look on his face or something like that. come on, you can't tell this guy was a serial killer or a mass murderer from that. His demeanor in court, and some people find that to be supportive of the idea that he's guilty, but to me, he's just a guy in court being charged with these crimes. He's acted completely as neutrally, I think, as he can. There's a statement or some stories out there that he stole his sister's iPhone many years ago. Okay. Right. And what's that got to do with stabbing four people? And if he claims that he's associated with other crimes and then it turns out he's not, but yet you don't purge that from your memory and remember that maybe you're wrong about that, that's kind of biased for the state beyond what the evidence is the state has. Now, the defense side, the presumption of innocence, it doesn't justify disregarding solid evidence. Who cares about DNA on a murder weapon? Who cares about the video of the car traveling? That stuff doesn't matter because of this other thing I want you to look at. Well, maybe the thing you want us to look at matters, but so does this other stuff. And the fantasy, which is not so much this case as it is the Richard Allen case, it also, and this is important for both sides of the case, it doesn't transform opinions into evidence. So on the pro-state side, you hear he looks cold and soulless. That's been on social media. He's been involved in other major crimes, even though we don't have evidence of that. And the kind of guy who would steal an iPhone would stab four people. I don't think so. I don't think one necessarily leads to the other. Now, on the defense side, he couldn't have done it in this time frame. Not buying that one. The guy in Japan stabbed, I think, 45 people in the time frame of about 40 minutes. That's pretty good throughput. And if you look at Ted Bundy when he went through the sorority house, was he watching a movie while he was in there? And unless you're doing things to other people while you're there, you can get the stabbing done pretty quickly. You can simulate it yourself if you don't mind being a weirdo. Walk through your own home and think of how long it would take to occupy yourself if all you're doing is stabbing people. So I think talking about his time frame as a potential for an issue in the case, that makes sense. And this gets back to Tom's point, is there more than one person? So I don't know why we would need to think that there was. I mean, as Ted Bundy went through the house and attacked four people, killing two of them down in Florida. It got the police called on him. And the only reason he left the house was because somebody was coming into it. While the police were there taking statements, he went down the street and attacked somebody else. He wasn't even so tired that night. And he didn't have a knife. He just had a stick of wood. So the time frame isn't, that's part of the story, sure. But I don't think it means there has to be other people. And I certainly don't think it means it's impossible for him to have done it. I don't buy that one. If you do, that's fine. But that's an opinion. Either way, my way or your way, is not evidence. No victim trace in the car. Looking at misspelling there, exonerates him. It doesn't exonerate him, but it could, potentially create reasonable doubt. It's an issue. I think, that matters if there's no trace evidence there. The defense should point that out, and they do. How could he have cleaned it out? What's going on here? But it is the case that sometimes people murder people and they don't end up with evidence in their car. The, murders close to where I'm at here, they didn't find stuff in the car. So a guy who's bagging his trash at 2 a.m. with surgical gloves on and putting it in somebody else's trash can, who's also pursuing a PhD and all this stuff and writing surveys up about how to commit these crimes and how to plan them ahead of time. If there was going to be a person who would plan ahead on how to mitigate this in terms of what he was wearing and what he could take off and put it into a giant bag or a cardboard box with a bag in it or something, he'd be the guy, right? So I respect the point that the no trace evidence is an important point. And if you think it creates reasonable doubt as compared to other parts of the evidence, I got it. But it doesn't mean it exonerates him, because it could be that he either cleaned the stuff out or took great care not to leave much or any of there in the first place, and it didn't get found. Someone else's DNA found in the party house is equal to the DNA on the weapon sheath. And that I do not buy as well. Now, again, back to Tom's point, could it mean there was more than one person involved? Yeah, maybe, but I don't see it that way, because, as other people have pointed out, there should be a lot of people's DNA in this party house. There are people going in and out of it all the time. There should be dudes' DNA all over the place. It should be a disgusting atmosphere if it's a college party house. Why didn't they find more DNA there? But just DNA of people coming and going from the house, even if you don't match it to somebody, because if they're not in a database, you won't. Can you really tell me that the first place you wouldn't look wouldn't be when you find the sheath for the murder weapon under the murder victim and you find one person's DNA on it? Maybe you go looking at that. Now, I get it. They're saying he's being railroaded because of that. They didn't look at these other people and bring that point forward. I think that's fine. It's just a theory, though. It's not conclusive as to whether he's innocent or not. All right, let's see. But how about our friend Darrell Brooks? Let's hit this guy. I've seen some chats that I missed because I was on trying to get through Kohberger, which is kind of complicated. Somebody said he's switching to a bench trial. I heard, I haven't seen any of that. I did have this note that the order to produce has been issued, and his trial starts roughly a week from now. This is for the shooting stuff, and it was in theory almost going to be a plea bargain situation, but they hadn't gotten there yet, so I don't really know what's going on with it. But I will try to find out. I'll put it on the stream when I get back in town if I can, because he's the car wreck. It's hard for me to look away from, and so if anybody has that in chat, I will be definitely looking at this. And it's let's see. I find it strange his dad came to Washington State to drive with his son home. Yeah, maybe not, right? And that's one of those things, right? I mean, my dad would have done something like that. I would do it because we're crazy and we drive across the country pretty frequently. We're getting ready to do it. So it could be and it could not be. It's just one of those circumstances. So, it's one of those things you have to be careful about dialing in on. And before we go into the pole vault, let me hit this because this super action. Oh, okay. Thank you. So see this comment now. It was converted to a plea hearing. So Darrell Brooks' situation has been converted to a plea hearing. So maybe something has been worked out there. Thanks for that late breaking news. I'll let you guys do these slides for me, and I will just read them because this is excellent late breaking stuff here. Now checking out the starred part here, because before the show even got started, we got a new member who received exclusive top secret benefits. And of course, Marsha Lim is generous in supporting this program, and Tom as well. We talked about whether there are more people involved. Again, I don't disrespect that theory. I don't think there has to be. Just my opinion. And another new member here, and Gringo Latina, which is not my wife. I'm not going to call her Latinx because I enjoy breathing. So let's go into the pole vault. And see what people had to say about some of these questions. So sometimes if I see something popping on comments and things, that's what's inspiring me to put these polls out there, because I want to hear what you guys have to say about it. And to me, pretty awesome answers. If you guys aren't lawyers, you're doing pretty well. So let's check it out. We did one a while back, just at random, because I saw it happening, was the right to confront. And here's this ninja witness. We talked about how, people need to come to court and testify if they're going to try and put people in jail, because you have a right to confront the witnesses against you. And yet here he is looking like this. So we asked the question, is that a violation of the right to confront or not? And look how you guys broke it down. There was 53% that said yes, and 47% that said no. That's about even. And that's learning pretty quick on the job, because, the framework for legal analysis starts with, it depends. And often for a judge, it's a balance. And we'll see how that affects here. So the face-to-face confrontation. So being in court in person, that's the major rule, right? And face-to-face is the norm. There can be, though, as this judge points out, some exceptions based on safety and security. I bet people pointed out in the comments, hey, people wore masks during COVID, right? Hopefully not in trouble for saying that word. And I have seen cases where undercover law enforcement people have been able to wear a wig and a disguise, maybe a ridiculous mustache and some sunglasses, but the jury can still see their expressions. Now, this guy's a little different because he's got a mask on. You can kind of see his demeanor, his expressions, maybe not so much. And sometimes they just clear the courtroom and say, well, I'm going to take everybody out of the courtroom. It's not the jury or the parties or their staff in order to protect this witness. But what was the result in this case? Let me pop this up here, and we'll see what the judge was doing, because, you guys were split almost half in this, and I think that reflects the judge's thinking on it.
Counsel, now your objection was previously stated as you're objecting to this witness testifying wearing a mask. Based upon his testimony, I overruled the objection, and now you're suggesting you want to revisit that?
Yes, sir.
So go ahead and tell me, make your argument.
May I inquire from the witness?
Sure.
Sir, are you aware that your picture, along with your family, is on the internet as we sit here today?
Nope. It doesn't miss that one.
We would object to him continuing to testify with his mask on, based upon that as public record.
outside. I guess my concern is, it's always something we're trying to balance things. The news crew has a right to be here and film what's going on in the courtroom. The defendant has a right of confrontation. Typically, it's face-to-face, but it's not hard and fast. The witness indicates there's stress on his life, and he's worried about his security of his family. And it's a balancing of all those things.
So there you have it from the judge. It's a balance of things. It can go either way. So everybody who answered this poll gets an A. So yeah, you should be able to confront people face to face, but the judge runs the courtroom, and if a little tweaking needs to occur, they can do it. The more you tweak it, the higher the risk that the defendant gets a successful appeal if he's convicted. So this judge is trying to balance that. And once they found a picture of this guy out on social media that his wife posted, I think they cleared the courtroom and said, okay, we're going to have him take the mask off, but no streaming, and we won't have just random people hanging out in here. I think is how the judge ended up handling that. So let's see. Yeah, also jurors had complained about it too. Jurors were like, what's this dude wearing a mask for? I don't like it. So there are some issues there. Fringe on the flag, of course, means you have to be especially careful if you're wearing a mask and you're a witness because of Admiralty Court law. All right, just kidding on that. We did another poll, which was the presumption of innocence. So I see this come up a lot, especially not only in terms of actually evaluating a case at trial, but before trial, which is cool. And also when arguing, when people are like, I presume everybody innocent, bro, so your arguments have no weight. And it made me think, what are the limits of using that? What are we doing here with presumption of innocence? So I set up this example of things that do happen and have happened in some of the cases we're talking about. That is, where if you presume the person innocent until they're convicted guilty, right? How can a judge say there's probable cause to believe the defendant committed the crime? That's not presuming the person innocent. How can a judge deny bail saying the proof is evident that the defendant committed the crime? Isn't that violating the presumption of innocence? And so I lawyerly put the word, do these orders necessarily violate a defendant's right to trial? Because they could potentially sometimes, but just in their essence, would they always do that? And a quarter of you said yes. That violates it. He's innocent unless and until convicted. And then some said no, not necessarily, and a few others. So 3-1 there. And I think that's probably a pretty good percentage too, because I'll explain, as I agree with the majority here, but I get where the rest are coming from, and let's look at it. It's not in the Constitution. So if you go reading your Constitution about the presumption of innocence, you don't see it in there, but it was recognized in a Supreme Court case in the late 1800s, traced all the way back to Sparta. So that's cool. And the central point of this thing is that the trial starts with the defendant presumed innocent. And we all think that's the appropriate way to do it, right? Because the state is hauling this person into court and putting them on trial and take their liberty away. And the state has all these resources. If you can't afford a lawyer, you just get the one the state gives you. So, there may be some odds stacked against you. They've done an investigation. They get to wear the badges. People kind of associate law enforcement with the judge. So the general idea is if they arrest somebody, they probably did it or did something. A lot of people think that, and that's why the presumption of innocence and getting a jury to buy into it is critical in a case, because you don't want the defendant who has everything else against them also being presumed guilty as the trial starts. So the state has to overcome this presumption of innocence with evidence beyond a reasonable doubt on every element of the crime. The defendant has no burden to put up any evidence at all, even though they often do. It's the state's burden, okay? The presumption of innocence is enough to sustain innocence if the state cannot get beyond reasonable doubt on every element. So that's the primary point of it, is at trial, but it does permeate the system. There's due process in the Fifth Amendment, and that kind of has the idea that citizens have rights. But we're not going to treat you like a criminal any more than we have to. That's why you have due process rights. And no excessive bail in the Eighth Amendment. So if we knew the person was guilty, why would we even care what their bail is, right? So sometimes the presumption of innocence actually gets mentioned in cases where they're talking about bail and pretrial detention, even though the real sources kind of are Fifth and Eighth Amendment. So for the 25%, congratulations, still giving you the passing grade because it does come up in high-level cases like that. But the general idea is if it's regulatory instead of punishment, then the societal interest in, say, pretrial detaining somebody because they won't show up at trial or because there's substantial danger to the public is generally considered a regulation that's part of the law enforcement that's going on, and not the punishment phase of it. So that's a little artificial, but that's the idea behind it. And you just got to have some kind of balance in these things. It's never just going to be one-sided one way or the other. So that's why you have the due process stuff in there, to make sure that somebody's at least getting a fair shot at hearings and things. So good job by the people answering the poll. If we could have a 400-person Supreme Court of people who answer these polls, I think we'd be getting some good decisions that reflect what the law ought to be and what the public thinks. So let's move it on from there. So here's what I'm going to say about this presumption of innocence, since I get slogged on it sometimes in comments by people say, well, what about this piece of evidence? And then I'll say, well, what about that one? And then they go, I don't have to think about that because I get to presume this person innocent. I think you're doing yourself a disservice, the same way as if the state has something on somebody, you close your mind to the potential that maybe the state's case is wrong, or that there's a reasonable doubt there. So think about it like this. In everyday life, you don't go around thinking the worst of anybody, right? But would you leave your kid with a predator-run daycare, somebody who's charged with abusing kids, but they're out on bail awaiting trial? Maybe they even did it before, but you want to presume him innocent. So you would put your kid right in there, would you? Would you walk in a dangerous area at night holding a pile of money? Because everybody you encounter is presumed innocent. Go around MS-13 gang members and say some derogatory remarks about them? Probably not. HR situations at work and mediating disputes generally, civil cases. Again, you're not going to start thinking the worst of somebody, or even if they did something, but this strong presumption of innocence is not how you handle the most of the things that you do in life. It comes out of the criminal trial aspect, and that's where it belongs. And it gets a little more attenuated as you move outside from that to, treat everybody decent kind of a thing, a due process, and not this no evidence matters kind of a thing. So therefore, for me, I say when you're analyzing true crime, know what the state's burden is and the starting point at trial, which is the defendant is innocent, and the state has to overcome that on every element of the crime that's charged beyond a reasonable doubt. Now you take that and you apply it to the concepts of what's in public domain. And so therefore, it's not a license to ignore evidence. Well, I don't care about the DNA on the sheath in the Kohberger case. I don't care about whether Richard Allen's confession may or may not be reliable, because, or I can make up a theory of absolute fantasy that aliens could have abducted these girls because anything's possible. The eagle could have dropped the round or whatever like that. It's just not a good reason to ignore evidence or promote fantasy, aliens. The comments that I get rid of off my channel when somebody tells me that the video of the guy on the bridge was altered to frame Richard Allen when you can't even tell it's him. Come on, people, don't do that. Just don't do that. Here's what the Idaho criminal jury instruction is on it. So when you have, say, Kohberger, who's facing a trial in that state, they're going to tell you that reasonable doubt is not a mere possible or imaginary doubt. That's in the court instruction. It's not just whatever you can think of. It is a doubt based on reason and common sense. All right? That's fair, right? Not a mere possibility or an imaginary doubt. So if you just fantasize some scenario that it isn't in the evidence and isn't even reasonable or logical or probable, is that reasonable doubt? Again, everything's a balance, not an extreme and stuff, but just you can't just say a talismanic phrase in the law and then that rid you of the burden of considering any kind of evidence and stuff if you want to have a rational discussion with people in either direction. I think this is the way that I see it. But I'm not the internet opinion police. And I will say, because I know there's a lot of traffic right now on the videos about how this person's innocent and that person's innocent and this other person's innocent and everybody's innocent. And some of those it could be right? But I'll just, to take the other side of the view, I will take the law enforcement side and say, you know what? Sometimes the people at the defense table are the right people that are there. Look at this gentleman on the right. You notice Kohberger is allowed to go into the courtroom without handcuffs on. He can wear a nice suit type outfit. He's not shackled or whatever. And they did that with Ted Bundy too. He walked around the courtroom, but I don't think Ted Bundy was innocent. So I think they got the right one there. And look at this gentleman here on the left. I wouldn't want to judge him guilty of the horrible crimes that he was accused of based on just his picture, but his behavior in court was consistent with that, as he murdered a young girl and a woman, and that wasn't all he did. But did you feel sorry for him when he was being led away? Let's take a look at this poor guy. I mean, how could anybody think that he would just burst into violence for no reason at all? Let's see him consulting with his attorney in a rational way just the other day after his hearing. So he went to the Taylor's Business Seminar on how to improve your relations with your attorney by communicating your dissatisfaction by attacking them. And that was a pretty sweet elbow there, right? He's like, hey, I need to ask you a question about the Fifth Amendment. The guy leans over and he hits him with the elbow. And the attorney, for his part, said that he has a fighting background. He's taken a lot harder hits than that. So he was golden. And he was asked right after that if he was okay. And he was super based and said, yeah. So cool defense attorney there, I think. But the guy, he gave him a good one. He could have had Herb Dean stepping in to stop that one. All right. Now, man, you guys are commenting a lot. So I've blown by a lot of these trying to get through this. I have seen several about the tiny ninja theory, and I brought that up a lot in the Murdaugh case. And to be flippant, right? Because they kept saying that the people who did the shooting had to be short. And that's ridiculous. The science didn't support that. The science did support that the low trajectory that the person might have been short or leaned down or whatever, but then they took it too far and said it had to be. So that's when I had to get into the tiny ninja thing, which is akin to the eagle of innocence. And that is, just because you have a theory doesn't mean that that's what the evidence demonstrates conclusively. So I think sovereign citizen stuff is terrible. I agree with that. And some comments on this. I mean, just look at this guy. It's sad to think a guy who looks like he could be your neighbor next door, right? Look at him. Would you ever think this guy was guilty of anything? Would you give this guy in this prison jacket here, or Ted Bundy maybe, but this guy right here looking straight at you on the screen, the presumption of innocence if he wanted to babysit your kids? And that's the point I'm trying to make here. Sometimes it's the right guy. Well, that went a little faster than I thought it was going to go based on all the developments in the case and how many slides I had. So that's what I got. So when this is over, if you guys, I've seen some comments on cases and stuff. You got cases that you want looked at and I have time to do it, put it in the comments after the video and I'll try and catch it. For members, we vote on topics and do the member streams for that. And I appreciate everybody who has participated in that. And I won't be doing any more live videos before 4th of July. So happy 4th of July to everybody. And I hope you guys all have a good weekend and are safe and have fun with your family and friends. And let's get over to here. And that's it. Thanks. Bye.